Hey everyone, Wayne Pollock here. I am often asked by plaintiffs' attorneys and their clients whether strategically it's better to seek publicity for a legal dispute from the get-go, or whether it's better to hold on to that card and play it down the road if we think the dispute needs a little bit of a spark to help resolve it in that client's favor. 9 times out of 10, I tell attorneys and their clients that it is better to get publicity for a legal dispute from the outset. And I'll give you 4 reasons why. First, the filing of a lawsuit is usually a newsworthy event, assuming that the lawsuit itself has newsworthy aspects. If you do not seek publicity for a lawsuit when it's filed, there's no guarantee that you'll have another event in the legal dispute that will be as newsworthy as the filing of the complaint or the opening papers. 2, when you get publicity for a case from the get-go, you now contribute to this self-fulfilling cycle where that legal dispute stays newsworthy because it was newsworthy at its outset. Meaning, if a spotlight is drawn to a legal dispute from the get-go, it'll be easier for you, the attorney, or your client to keep that momentum going because you'll have a reporter who already covered the case, and they'll be more interested in further developments because they already covered the case and they know the case is newsworthy. Third, if you seek and get publicity for a case as a plaintiff's attorney or as a plaintiff, you are putting the defendants in an interesting position. They now know that the case has been covered by the press. They don't know what's coming next. They don't know if there'll be subsequent media stories. That might impact how they handle the litigation and how they develop their litigation strategy. On the flip side, if there wasn't any publicity, they're not thinking about it, and they're not worried about what they're doing drawing a spotlight to them. Fourth, when you're a plaintiff's attorney or a plaintiff and you're getting publicity for your case from the outset, you are giving reporters and the public more time to digest what the case is about and to come forward with either more stories in the case of a reporter who has more time to dig into the case and do some research, or on the part of the public to come forward with more information that you might not have known or might not have known but for later developments in the case. So for example, you could have reporters who are intrigued by the allegations of wrongdoing and do their own research and come up with a series of articles that really are damaging to the defendants. On the other hand, you could have members of the public come forward and say, hey, I saw this article, I worked at this company, my sister worked at the company, whomever, I have this information, and now you get the benefit of this third-party information that you wouldn't have gotten had it not been for the publicity at the outset in the case. Now, there are some times when, as a strategic matter, you do not want to get publicity for a case from the outset because you've got delicate and tense settlement negotiations and you don't want the publicity to somehow derail those. But in my experience, those instances are few and far between. That's why I encourage plaintiffs' attorneys and their clients to seek out publicity about a case from the get-go. I think it is more powerful to frame the lawsuit as one that's newsworthy and have that theme running throughout the case, as opposed to saving the seeking of publicity, saving the newsworthiness component for a later time when it might be too late to take advantage of all the benefits that publicity can give an attorney and a client.